senior ranks are to be the senior practitioners of tomorrow.
Mr. Chairman.
The Honourable Leanne Dalzell.
Mr. Chairman, I wish to participate in this part of the debate on the short title and commencement of the legislation that we have in front of us. I did participate in the debate on part one of the bill, and I did make a couple of points that I'd like to reiterate, in the sense that where this legislation has its commencement date does in fact relate to the specific proposals with respect to Queen's Counsel. And I think that the disappointment that we have expressed on this side of the House actually relates to the fact that the legislation itself is due to come into force presumably by way of supplementary order paper updated from 1 July 2010, which was the date that was the date that it was intended to take place when this bill actually was originally referred to the Select Committee. And so it's obviously been at the Select Committee for some time, with the supplementary order paper now having it come into effect on the 3rd of December 2012. And I thought it was quite interesting, because when the legislation was originally in actual fact, I think it's the clause-by-clause analysis of the bill that's incorrect, because when one looks at part one was always due to come into force on 1 July 2010, and so, but clause 2 of the supplementary order paper requires that we replace 1st of July 2011 with 3 December 2012, and so I'm just wondering whereabouts one can replace the words 1 July 2011 if they don't appear in the legislation.
Well, it can't commence.
So that actually just, I wonder whether that's correct or incorrect. The Minister and the Chair perhaps could get some advice from her officials and perhaps respond to us, because the way that it reads at the moment is the commencement. It says Para 1, Part 1 comes into force on 1 July 2010. That hasn't been amended at the Select Committee. The Minister's supplementary order paper says Clause 2 and Clause 2.1 replace 1 July 2011 line 5 on page 2, or line 5 on page 2 says Part 1 comes into force on 1 July 2010 on the copy I've got, so maybe I've lost something. Maybe I've got the original copy. Yes, I have got the original copy, so it's been updated since it was referred back from the Select Committee. So it's obviously been at the Select Committee for a long time, and obviously my colleague, my very honourable colleague Charles Chauvel, has handed me an old copy of the bill and not the reported back version from the Select Committee, because I see that it is in the name of Nathan Guy, who is presumably not the Minister that's taking this through now, is he? Or it's back into the name of the Minister? Or, yeah.
Not sure.
Do we know whose name the bills is in? It's back with the Minister of Justice, so it's been diverted back to her. But anyway, so at the question that obviously the Select Committee had to deal with at such a... oh yes, here we go. So now that we've got the copy of the bill that was reported back from the Select Committee, it says Part 1 comes into force on 1 July 2010, struck out 1 July 2011, replaced, and now this is replaced with the supplementary order paper in the name of the Honourable Judith Collins with the 3rd of December 2012. And that, of course, is not very far away, and no doubt that's why we're seeing this bill passed into law through the House at this stage. It is, though, I guess, a particular shame and a disappointment to this side of the House. We think that modernising the way our legal system operates, separating that, or creating a distance from our traditional past in the UK, seeing ourselves now reinstated to the previous position of senior counsel being replaced with Queen's Counsel, I think is a retrograde step, and I think it's very disappointing that the House is having to deal with this in this way.
Members, we come to the vote on the clauses. The question is, at Clause 1 stand part. Those of that opinion will say aye. To the contrary, no. The ayes have it. Party vote's called for. Ask the clerk for a party vote.
New Zealand National.
59 votes in favour.
New Zealand Labour.
4 votes opposed.
Green Party.
14 opposed.
New Zealand First.
8 votes opposed.
The Maori Party.
3 votes in favour.
Mana.
1 opposed.
ACT New Zealand.
1 vote in favour.
United Future.
1 vote in favour.
Members, the ayes are 64, the noes are 57. Clause 1 will stand part. We now come to Clause 2, and first we have the Minister's amendments to Clause 2 as set out on SOP number 136. The question is that the amendment be agreed to. Those of that opinion will say aye. To the contrary, no. The ayes have it. The ayes have it. Ayes have it. The question now. Well, I'm sorry. Well, that's why member must be more. Yeah. Party votes called for. Ask the clerk for a party vote.
New Zealand National.
59 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party.
14 opposed.
New Zealand First.
8 votes opposed.
Maori Party.
3 votes in favour.
Mana.
1 opposed. 1 vote.
ACT New Zealand.
1 in favour.
United Future.
1 in favour.
Members, the ayes are 64, the noes are 57. The amendment is agreed to. The question now is that Clause 2 is amended stand part. Those of that opinion will say aye. To the contrary, no. The ayes have it. Party votes called for. Ask the clerk for a party vote.
New Zealand National.
59 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party.
14 votes opposed.
New Zealand First.
8 votes opposed.
Maori Party.
3 votes in favour.
Mana.
1 vote opposed.
ACT New Zealand.
1 vote in favour.
United Future.
1 vote in favour.
Members, the ayes are 64, the noes are 57. Clause 2 is amended, will stand part. The question is that Clause 3 stand part. Those of that opinion will say aye. Aye. To the contrary, no. The ayes have it. Party votes called for. Ask the clerk for a party vote.
New Zealand National.
59 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party.
14 votes opposed.
New Zealand First.
8 votes opposed.
Maori Party.
3 votes in favour.
Mana.
1 vote opposed.
ACT New Zealand.
1 vote in favour.
United Future.
1 vote in favour.
Members, the ayes are 64, the noes are 57. Clause 3 will stand part. I will report this bill with amendment presently. Members, we come now to consideration of the electronic identity